I'm delighted to welcome you here. Even on this rainy day, it seems that the rain has been a deterrent for some, but I'm glad to see all of you here today. And to welcome you on behalf of the School of Information at UC Berkeley, or the iSchool. For those of you that don't know what the School of Information is, we are focused on doing research and teaching at the intersection of information, people, and technology. So this session today is of sort of core interest to what we do. The person who really should be welcoming you here today is Professor Deirdre Mulligan. Deirdre is one of the, she's in the School of Information and one of the leading scholars of information policy and privacy, but Deirdre unfortunately had to leave town at the last minute. I'll just give you one anecdote about how this came about. Deirdre called me a couple months ago with a lot of energy and said, "Oh, look it, the P Club is coming to town. We've got to get them to campus, P Club." And I said, "Oh, P Club?" I had never heard of it, but as you may well know, Privacy and Civil Liberties Oversight Board is an independent agency within the executive branch of the U.S. government. It was established in 2004 to advise the president and other senior executive branch officials with respect to privacy and civil liberties, and to make sure that those considerations are at the forefront in developing and implementing all laws, regulations, and executive branch policies related to terrorism. I think you'll hear more from the members themselves about how that is going. But I'm delighted that they made the trek over to the East Bay for us. I want to, in addition to welcoming you, thank the other sponsors for this event. Trust, the Team for Research in Ubiquitous Secure Technology, the Berkeley Center for Law and Technology, Citrus and the Data and Democracy Initiative, and Miller Institute. And last but not least, I'd like to introduce the moderator for today, Professor Paul Schwartz. Paul is a leading international expert on information privacy law. He's the Jefferson E. Pizer Professor at the Berkeley School of Law and a director of the Berkeley Center for Law and Technology. Paul is also a special advisor at Paul Hastings, where he works in the privacy and data security practice. He has also been very much involved in policy-related issues, governance of information privacy, regulatory issues. I can't imagine a better, except for Deirdre, a better person to moderate today. So please join me in welcoming Paul Schwartz.
Thank you so much for that warm introduction. What I'd like to do is I'll first tell you how we'll do the event today, and then I'll introduce the board and the commentators, and then I'll tell you a quick anecdote, and then I'll be quiet. So I've got it all planned out. So first of all, we will have the board present for about 30 to 40 minutes, and then we'll have the commentators each speak for about 10 to 15 minutes. And so now, the commentators will first hear from Anne, and then from Susan, and then from Lee. So now it's my pleasure to introduce the board to you. So David Medine is the chairman of the Privacy and Civil Liberties Oversight Board. He started full-time as chairman of the Privacy Board on May 27, 2013. Before that, he was Attorney Fellow for the Security and Exchange Commission and a Special Counsel at the Consumer Financial Protection Bureau. From 2002 to 2012, he was a partner in the law firm Wilmer Hale, where his practice focused on privacy and data security. David started out in academia, so always got to mention that, and he taught at the Indiana University Bloomington School of Law and GWU School of Law. Our next board member is Rachel Brand, and she's been a member of the board since 2012. In addition to her service on the board, she's Vice President and Chief Counsel for Regulatory Litigation at the National Chamber Litigation Center, which is the litigation arm for the U.S. Chamber of Commerce. Her prior government experience includes serving as the Assistant Attorney General for Legal Policy at the U.S. Department of Justice. We also have from the board Elisebeth Collins Cook, who has been a member of the board since 2012. She's also a counsel at Wilmer Hale. Previously, she served as the Republican Chief Counsel of Supreme Court Nominations for the Committee on the Judiciary of the U.S. Senate. She also served as Assistant Attorney General for Legal Policy, U.S. Department of Justice. Final board member here today is James Dempsey. He served as a member of the board since 2012. He's also Vice President for Public Policy at CDT, the Center for Democracy and Technology, which is a non-profit public policy organization focused on privacy, national security, government surveillance, and other issues. He joined CDT in 1997 and has held senior roles in that organization. And I think what I'll do as well is I'll introduce our commentators as well. So Ann Joseph O'Connor is a colleague of mine. She's Associate Dean for Faculty Development and Research and Professor of Law at UC Berkeley School of Law. She teaches Administrative Law, Civil Procedure, and E-Discovery, and she's also taught in the Department of Political Science here at UC Berkeley. We'll also be hearing from Susan Landau, who's Senior Staff Privacy and Analyst at Google. She was previously a distinguished engineer at Sun Microsystems, where she worked in cybersecurity, privacy, and public policy. Among her numerous books, she's the author of Surveillance or Security, The Risks Posed by New Wiretapping Technology, MIT Press, 2011. And then our final commentator is Lee Tien, who's Senior Staff Attorney with EFF, specializing in free speech law, including in the intersection of free speech law with intellectual property and privacy law. Before joining EFF, he was a sole practitioner specializing in FOIA litigation. I should also mention that Lee went to the greatest law school in the world, namely Boalt Hall, University of California at Berkeley. Okay, so now I'm going to tell you my quick story. So the quick story is, which I have to think when I'm introducing the board, is for a number of years I had the pleasure of chairing a privacy law conference that went over a day and a half for the Practicing Law Institute. And we did it in New York, and then we did it in San Francisco, and eventually I got too busy here at Berkeley to do it, and so I handed off the responsibility of being the co-chair. But I did it for about 11 years, including before and after 9/11. And one of the tasks that I took on after 9/11 is we had someone from the Department of Justice who had a deck that he had done about it wasn't called this, but it was Don't Worry About the Patriot Act. And he explained how the Patriot Act really didn't change anything, and how there were, various kinds of authorities, but it didn't even went through the whole thing. And so what was so great is I eventually got to give the deck myself. After hearing it, he didn't really update it, and so he was a middle kind of rank person doing computer security stuff. And so I got to be the kind of stand-in because he got a really bad flu. The event was in San Francisco, and I was kind of like an honest broker of the thing. I kind of had my little doubts, but I gave his deck as it was. And so I just kind of went through it. I'd seen it many times, and it was kind of great, acting the role of somebody from the Department of Justice. But what strikes me in kind of thinking about that moment is, I guess the punchline is I would do it a little differently today. Because we know so much more about what was being made of, the use that was being made of the authorities that were granted in the Patriot Act. And a lot of that is due to the work and the report of the Privacy and Civil Liberties Oversight Board. And we have them here today, and it's just our pleasure, it's our honor to welcome you. So that's my story.
Okay. Well, thank you, Paul. And on behalf of the board, thanks very much for the invitation to be here. Thanks to the high school and the other sponsors of this event. I should add that any views we express today will be our own views, not necessarily the views of the board. I actually had a similar experience. I was called by the White House in September 2011 and asked if I'd be interested in being nominated to be the chairman of the Privacy and Civil Liberties Oversight Board. And my first response was the same thing, which is, what's that? And so after looking it up and figuring out what it was all about, I was eventually nominated later that year in December of 2011, and the Senate took 510 days to confirm me, but I ended up starting work at the board 4 days before the Snowden leaks, so there was some forces at work to put me here. I might have preferred a little bit more ramp-up time, but it's made for a very exciting several months. I'm going to talk a little bit about the board and what we're all about. Jim Dempsey will then talk about our recent report and our analysis of Section 215. Rachel Brand will talk about the recommendations we made regarding the Foreign Intelligence Surveillance Court, and Beth Cook will talk about the transparency recommendations we made in our report. Just as background, after the 9/11 attacks, as I think you know, a 9/11 commission was created to study what went wrong and how we could do a better job of protecting the country, connecting the dots, gathering information. And at the very end of the 9/11's fascinating report, after about 500 pages of how we could beef up our intelligence gathering, and they made it in a couple of paragraphs a recommendation that said, let's be cautious not to go too far in the direction of national security without properly taking into account privacy and civil liberties, with the, I think, important concern that we protect both and that we can protect both at the same time. And if we sacrifice one, it hurts the other. And so that's really been the guiding mission of the board in our statute, is to properly balance privacy and civil liberties with national security concerns. We're a permanent organization. We have 5 members. Unfortunately, one of our members, Judge Pat Wald, couldn't be here today, but we each serve staggered 6-year terms. We have no more than 3 members of any political party, and we are independent. And I think independence is really critical. There was a prior iteration of the board that was located in the White House, and a concern was raised that the board wasn't sufficiently independent. And so Congress recreated us as an independent agency in the executive branch, which is a very unusual formulation. But I think the key thing for our purposes is that we are independent. And what that means is that our reports, our recommendations, are not reviewed by the White House or the Office of Management and Budget, but basically we vote and say what we think, and we may or may not agree with the administration or others. But we are set up to with high-level security clearances, so we have full access to government programs, but with the opportunity to express our own views. And we don't have any powers other than to report and advise the President and Congress and the general public and be part of the ongoing debate. The board has 2 major functions. One is oversight of existing intelligence programs, and our statutory jurisdictional limit is counterterrorism programs. And as part of that oversight function, we recently prepared the report that we'll talk about today on the Section 215 program. After the unauthorized disclosures back in June, we were asked by members of Congress and the President to conduct a study of the 215 program, again, which we've now completed, and also asked to study the 702 program. And about 2 days after we issued our 215 report, we turned to the 702 program. We're going to be holding a public hearing on March 19th to discuss the program, because the board believes in operating as transparently as possible and getting public input where we can. But over the next couple of months, we'll be completing our report on the 702 program. Another part of our function, other than oversight, is advice. And we view that as very important. It will be less public, but we want to be a resource to the intelligence community and go in as programs are developed to provide privacy and civil liberties advice as new programs are developed. In the private sector, that's called privacy by design, where it's a lot more efficient to build something in and then to retrofit it after the fact. And we've already begun that process of being invited in by intelligence agencies and just have programs described, and we've had the opportunity to provide input into those. And that will be in a classified environment oftentimes, but we think that that's a real unique feature that the board offers and something that we plan to continue to do. We've received tremendous cooperation from the executive branch in getting access to information, whether classified briefings, foreign intelligence surveillance court decisions, and that's obviously been critical to our functioning, but we've received cooperation and gotten as full a picture as we can. We have to ask tough questions, and we have to reach out to other sources besides the government, the private sector, advocacy groups, as we analyze programs and get information, but we've certainly received tremendous cooperation to date. And our mission on the oversight side is to do two things. One is to look at the privacy and civil liberties versus national security concerns, again, and how do we balance those, as well as analyze whether the programs we look at are consistent with law. And we'll probably have some discussion about the scope of that analysis. But with that's pretty much our oversight of our structure, and then I'll turn to Jim to talk about our recent analysis of the 215 program.
So about, I guess, a month ago, we published a report, publicly available, pclob.gov, all, whatever it is, 239 pages of it, in which we looked at the so-called 215 program, which is the telephony metadata bulk collection program conducted under Section 215 of the Patriot Act. And we also looked at the operation of the FISA court, which had approved the program, and we looked at issues associated with transparency. As David indicated, we bifurcated. We started down the road. In fact, we had already started before the Snowden leaks. We had started in looking at 702. And after the leaks occurred, we intensified our examination of 702, 702 being the content collection program conducted under Section 702 of the Foreign Intelligence Surveillance Act, what people sometimes refer to as PRISM. So PRISM, or 702, is the content of communications. 215 focuses on metadata, to, from, and other transactional data. How many lawyers or law students in the room? So sort of half, disproportionately on this side of the room. The law, our legal system draws a distinction constitutionally based between the content of communications, which are relatively highly protected, and metadata, or information about communication, sort of to, from, dialed number information, who's calling whom, which has constitutionally been afforded zero protection under the Fourth Amendment. And these two programs, to some extent, reflect that legal, constitutionally derived distinction. We ultimately decided in the fall that we would bifurcate our examination and we would hold off on the 702 for a bit. We just realized both programs, the way we were approaching them in depth, required attention at such a level of detail, and the debate was moving forward relatively quickly on the telephony metadata 215 program, that we decided we better bifurcate, get our work product out and into the debate on Section 215, and then return to the content collection, or PRISM program, which we're taking up now, and which we will have a second report on. In looking at the program, we looked at legal briefs filed by the government and applications to the FISA court, opinions of the FISA court. We've spent considerable time at NSA talking to people who run the program, who handle the data, who analyze the data. Spent a lot of time talking to Justice Department officials and others who provide oversight of the program. As David said, we received full cooperation. None of us felt that there was any piece of information that we needed that we didn't get, nothing that we asked for on this program that we didn't get. If anything, there was a flood of information that at times was difficult to keep up with. I think outsiders have to realize just how heavily lawyered pretty much any intelligence program is, including particularly both of these programs, with layers and layers of review, both inside the NSA, at the court, at the Congress, by the inspectors general, et cetera. We had access to inspector general reports on these programs, et cetera. We looked very closely at the statute itself. This is so-called Section 215, or Business Records Statute. And we looked at, as well, in depth at the case studies or success stories or examples that the executive branch offered as showing the utility of the program. And in my view, I think we did a more in-depth analysis than anybody anywhere else in the government had ever done of the statute and of the information pertaining to the effectiveness or utility of the program. And we got pretty much all of that. I would say we got all of the legal analysis, and we got a lot of information about very specific cases cited by the government into our public report. And I think that the chapter on the legal analysis, the statutory analysis, and the chapter or section talking about effectiveness are the most in-depth analysis ever done by anybody in the lifetime of this program. We also looked at the constitutional issues, looked at the Fourth Amendment implications and the First Amendment implications. We concluded on the constitutional issues that we sort of concluded, I would say, three things. One, if you applied the existing case law, again, for the lawyers, Smith versus Maryland, the case holding that there is zero constitutional interest in dialed number information, if you applied that to this case, you would come to the conclusion, as did the government lawyers, as have the judges who have looked at this, most of the judges who have looked at this, you would come to the conclusion that there was no constitutional Fourth Amendment violation. And if you look at the First Amendment holdings, you would not find a clear indication, at least, that this was unconstitutional as a matter of First Amendment. Clearly, it raises privacy issues, which is partly what the Fourth Amendment addresses. Clearly, it raises right of association issues, but a one-to-one application of the case law would lead you to conclusion quite clearly on the Fourth Amendment side that there was no constitutional violation. Secondly, we concluded that the Justice Department lawyers and the other lawyers who relied upon those cases were justified in doing so. Thirdly, at least a majority of the board, and maybe all the board, but certainly I came to the conclusion that a one-to-one application of Smith versus Maryland, the argument that there is zero constitutional protection in one person's dialed number records, a one-to-one application of that to this situation really was not satisfying, really did not work. Where the court will go, no one can predict. The bottom line is there has never been a constitutional case posing the question, certainly no Supreme Court case posing the question about this much collection of data. Obviously, there are those who argue that an infinite number of zeros is zero. I'm not sure that really is the right I personally believe that is not the right constitutional analysis, but we have to see where the court goes. On the statute, a majority of the board concluded that reasonable people acting in very good faith and doing something which was very good, which was bringing a program that had previously existed outside of any statutory authorization, bringing it under a statute and bringing it under court orders, clearly had done the right thing in moving what had been an extrajudicial program under the court supervision. They still got it wrong. And it was the conclusion of the majority of the board that the statute could not bear the weight put upon it, and that reasonable people get things wrong. That's what appellate courts are all about. That's what review is about. And I felt, again personally, that I had to come forward and say, this just doesn't add up. And I was influenced there not only by this one program, but by the fact that the government had taken the statute, which was, in my mind, clearly not a bulk collection statute, not a statute suited to bulk collection of data on an ongoing prospective basis, basically close to nationwide coverage, a statute clearly not designed for that purpose, had shoehorned the program into that, and in the process had said, in essence, other data sets could be, of other kinds of data, could be also justified under this statute. So I was thinking not only about this program, but the next program and the next program and the next program, and had to come to the conclusion, if we are going to have bulk collection, and I, for one, am not prepared to say never, ever in the era of big data, but if we are to have bulk collection, this is not the statute for bulk collection. And the words used in the statute, the concept of relevance, had to be twisted or extended far beyond in order to get there, and that was wrong. And we need to pull back from that and reconsider where we're going with bulk collection, if at all. We also concluded that the data about effectiveness just didn't add up. And the majority of the board concluded that it did not, that it was not justified. We can go into a lot more depth on that. I don't want to eat into other people's time. I don't want to dwell too much on the dispute between the majority and the minority. I will say one last thing, which I feel that as a board, as a sort of a collegial body, I believe we spent far more time on this in debating and discussing and understanding and going back and forth and trying to reach resolution. In our report, 12 recommendations, 10 of them unanimous. We spent a lot of time on this as a board, really diving in on this, and I think far more, possibly even in the sort of, I don't know what the framers of this idea had in mind, but I'll simply tell you, we spent a lot of time in very collegial discussion and debate to get to this product. So that's my overview of at least the 215.
Okay. Rachel's going to talk about
and,
yes.
And Rachel and Beth can go into also their explanations, which are in their supplemental views or their dissenting views about why they disagreed with the majority of the board's, the majority's conclusion. But it's all in this report.
Well, thanks for having us. I love coming to Berkeley. It's such a beautiful place, and we've been all around the Bay Area the last 2 days with meetings. We've been riding around in a minivan together, literally. David's an excellent driver, as it turns out. So, but we're happy that we could fit this visit into the program. So in our division of labor, I'm going to be addressing the section of our report that addressed the FISA. We call it the FISC. It's the Foreign Intelligence Surveillance Court, which is the special court created under the Foreign Intelligence Surveillance Act. But before I get to that, I did want to just add one. I agree, let's not get into a debate here necessarily. As Jim mentioned, Beth and I dissented from the board's conclusion that the statute did not support the program, and its conclusion that as a policy matter that the value of the program didn't justify it. We dissented from that, but and you're welcome to read my 5-page dissent and Beth's 5-page dissent if you want to know all the reasons why. But one thing I think it's important to keep in mind that's a factual matter, and forgive me for adding on to your presentation, is I think there's a lot of misunderstanding about what the program is. So we're talking about metadata, and I think in this audience there are people who know far more than I about what metadata is, but you're essentially talking about phone numbers, calling phone numbers, dates and times that the phone calls are made, and the duration of the call. That's essentially what it is. There's no personally identifying information at all collected by this program. So you have, 202-555-1212 calls another phone number, and there's nothing in the system that says who belongs to either of those phone numbers, right? And the government, most of that, the vast overwhelming majority of that information is never viewed by any human being. The government can only look at that data if they have a particular terrorism, they have a particular phone number for which there is evidence. The standard is reasonable articulable suspicion. So if you have reasonable articulable suspicion that a particular phone number has a connection to terrorism, a very small number of trained and cleared analysts can go into the system and look at what phone number is called that phone number. That's what it is. And so you can all draw your own conclusions as a policy matter about the privacy implications of that. But that limited nature has gotten completely lost in the press. I think people think the program is the NSA listening to their phone calls, or they think that the government is sort of comprehensively looking at, when I called my doctor, those sorts of things. That's just not what the program is. And so I think it's important to keep those facts in mind as you analyze the program. So turning to FISC reform, we had 10 recommendations in our report. The recommendations on this subject were unanimous. All 5 of us agreed that there should be some adversarial nature to the FISC's operation. So for those of you that don't know what the FISC is, it's a special court that has the sole function of approving surveillance applications that the government brings to it in a limited set of circumstances. There are wiretap applications, search warrant applications, business record applications, which is what Section 215 is. The judges on this court are regular Article 3 lifetime, Senate-confirmed lifetime tenured judges that are selected by the Chief Justice to serve on this court in addition to their regular duties in their home district. So you might have a judge from the Northern District of Illinois who serves on the FISA court for a term of years, and every once in a while goes and spends a week in Washington, D.C. in a secure facility hearing applications by the government to do wiretaps and search warrants and so forth in the foreign intelligence surveillance context. The court operates ex parte, which in this context means that when the government goes to the court and asks for a wiretap, the subject of the wiretap isn't there to contest the wiretap application. That's what it means to have ex parte proceedings. And in that respect, the FISC's operations are no different from a regular court hearing a wiretap application in the criminal context. Obviously, the subject in a mob investigation, the subject of the wiretap isn't there. Their lawyer isn't there in the court to contest the government's ability to get the wiretap from the court. But after the Snowden leaks, a lot of concerns came to the fore about the operations of the court in secret. Now, you can imagine why, in a classified context, and frankly, in any wiretap context, why the court would operate in secret, but that became the subject of a lot of discussion. And there was also concern about the just general lack of an adversarial process. So there are no third-party views are being expressed to the court in any of its proceedings. There was a suggestion, at least in the tenor of a lot of the reporting, that the court is a rubber stamp, that it gives the government a free pass, that it lacks independence. And so as a result of all of that, there were many bills introduced in Congress to create a special advocate or some other adversarial type process in the court. So we looked at this in a great amount of detail. We looked at all the bills that are pending in Congress and came up with what I think is one of the most balanced and nuanced approaches to providing adversariality into the FISC's procedures. So we agreed, first of all, unanimously, that there should be some opportunity for third-party views to be received by the FISC. We think, or at least I think, that the court already operates with a high degree of integrity. I think that the judges serving on the court take their job very seriously. They do not give the government a free pass. I think all of us agree that the sort of suggestion that the FISC is a rubber stamp is just false. You can see that in some of the declassified FISC opinions. The court really held the government's feet to the fire when the government screwed up. And you can see that now in the declassified opinions. You can also tell from the fact that the government takes very seriously its requirement to go to the court and report on itself when it screws up. And the court, the government, I don't want to say it's scared of the FISC, but it kind of is. I mean, it knows that if it screws up, it's going to get hammered. And so whenever there's even the smallest technical infraction, the government goes to the court and reports on itself, and then the court deals with the issue. But despite all that, we did agree that there is a lack of public confidence in the FISC, partly because the public misunderstands how it works, but also because that there's a concern about lack of adversariality and secrecy. And so we thought that some opportunity for third-party views in the court would improve public confidence, which would be valuable. We also think that just as a generic matter, it would be valuable to have third-party views in the court in certain important cases, and we think that the judges of the court would actually welcome those views in novel applications. Like, for example, when the 215 program was initiated, the government had to go to the court and say, okay, we want to do this bulk metadata telephony collection program. Here's our legal theory for why it's permissible under the statute. Will you approve it? In a case like that, the court very well might want adversarial briefing, to kind of help it flesh out its own views. And we think that, based on our conversations with current and former FISC judges, that they would welcome that. The devil, though, is in the details, and the bills pending in Congress have a wide range of proposals. Some of them would create an entirely new bureaucracy, a whole new agency, so to speak. Not clear to me which branch of the government that would fit in, but that would be permanently staffed by the same lawyers all the time. Other proposals would have a pool of outside lawyers, almost like amici, that the court could call upon. They're all different flavors of proposals. We proposed creating a pool of what we'll call special advocates. That term is used in some of the bills pending in Congress. A pool of special advocates who would be lawyers outside the government. They could be law firm lawyers. They could be lawyers from NGOs, people who are selected because of their expertise in the subject matter. They would be selected by the FISC, and they would be sort of on call. And then in cases presenting novel legal issues or otherwise very important cases, the court would call upon an individual lawyer to come, review at least some of the materials that the government is presenting to the court, and then provide the court with his or her views. We did not propose creating a new permanent agency in the government because we think there are a lot of downsides to that. One is a very practical issue, which is workflow. You might have a time when there's way more than one lawyer can handle, and you may have a month go by where there's just nothing for the person to do. As I said, it's not clear to me what branch of government that person would sit in, and I have a serious concern about separation of powers issues, so that was important to me. And there's also a risk that a lawyer whose sole job it was to appear in the court to do this would be captured by the process. I think it's better to have people who are truly independent and do another job most of the time come in and give really independent and fresh views to the court. We also did not recommend that the special advocate participate in every application to the FISA court. The FISA court hears a lot of applications. Most of them are completely routine, say a wiretap application. And the judges on the FISC are very capable of applying the law to the facts in a routine matter just as they do in a typical criminal wiretap application. Injecting the special advocate there would not really add any value, and it would slow the process down, because in the individualized applications, you can imagine it can be very fast-moving with the national security investigation, and so we didn't want to, we didn't think it's appropriate for every application to go. At the end of the day, we would leave it to the FISA court to decide which cases were novel or very important and which cases they would benefit from the special advocate's views. We do think it would be appropriate for there to be standards that the court would consider in deciding which cases were novel. That would both improve public confidence and give some sense to the government and the court of what it was doing. We would, though, have the court report to Congress and the public on the cases in which it called on the special advocate. So, the public confidence would not be improved if the special advocate were never called upon, and if the public never knew how often the special advocate was called upon. And so, we didn't prescribe the details of the reporting, but if the court reported the number of times that the special advocate was called upon, and perhaps there could be reporting on additional details that would improve public confidence. Let me see what else we should. I want to go into all the details, so my time is getting short. But one thing that we thought was important was that it not be a truly adversarial process. So in normal litigation, a lawyer has an obligation to advocate for its client. It's a truly adversarial process. Either one side's going to win or one side's going to lose. But here we call upon lawyers to look at the issues presented to the court and decide whether or not they want to oppose the government's views. That the person may decide that, actually, I don't think that the privacy implications here are so great that the government's application should not be granted. So the person would come and read the materials and present legal arguments presenting privacy and civil liberties issues as they sort of struck the lawyer. We also thought it was important for there to be some mechanism for appellate review. We did not recommend that the special advocate have procedural rights like a party in litigation would, because there are standing concerns with that. Standing concerns, frankly, are the main concern. But we would allow the special advocate to, for example, ask the court to certify an appeal to what we call the FISCR. It's the FISA, Foreign Intelligence Surveillance Court of Review. It's the appellate body that reviews decisions by the FISC. And so then it would be at the court's discretion whether or not to hear the appeal or to certify the appeal. But there would be some mechanism for the special advocate to say, the court didn't go with my view, and I think it merits additional review. So I think that covers our recommendations on the FISC.
So I think we are starting to eat into other people's time, but I think it's important to talk a little bit about our approach to transparency and the recommendations that we made regarding transparency. To take you back a little bit in time, before David was confirmed, the 4 part-time members had been confirmed, and we were beginning the process of setting our agenda. And more than a year ago, or approximately a year ago, but before the Snowden leaks, one area that we identified of particular interest to us was increasing transparency with respect to our national security programs. One can see the benefits of this in terms of increasing public confidence and understanding of what the government is doing, and in a democracy, increasing the ability of the voting public to make informed decisions about what their representatives are going to be doing on their behalf. By the same token, historically, I think we've always accepted that there is a balance there, and providing a roadmap for our adversaries to evade our surveillance and our national security programs comes with a cost. There are some who I think would say it's a cost worth bearing. As I'll indicate a little bit more, we had 5 recommendations, 4 of which were unanimous on the board, and where 2 of us did part ways was on this last issue as to where do you draw the line, specifically when you're talking about legislation, when you're talking about the authorities that the government has. And I'll explain sort of how I think this precise program raises the very concerns that split the board on how much we can discuss publicly. But as others have said, it's important to understand that we were unanimous on 4 out of 5 of our recommendations, and this is an ongoing subject of interest for us. I'll also say these are the highest level of recommendations. We have made these 5 recommendations and also noted, though, that they should be implemented to the extent possible consistent with national security. And I think here is where we can also perform a valuable part of our advice role, is really implementing these recommendations and working with the judiciary and the FISA court and working with the executive branch as they move forward in implementing our recommendations. So we started with recommendations about the operations of the FISA court. So in addition to recommending the creation of a special advocate who would participate in certain types of cases, we recommended that the court continue its more recent practice of drafting opinions in novel and important cases in a declassified form to the extent possible. We also recommended that the court attempt to go back to some of its more important and novel opinions and declassify them to the extent possible, recognizing 2 things. One, our recommendations will have a cumulative burden, and this is a small court. This is a court that does have day-to-day operations that are incredibly important. The other part that we recognized is that the opinions were never drafted in a way to be made public, and it's very difficult in some of them to disaggregate core facts from the legal analysis. So we did make 2 separate recommendations, understanding that the retrospective, I think, is going to be a much tougher road for the court, but one that the court should pursue. And that would be in conjunction with the Department of Justice and the lawyers at the Department of Justice. As Rachel mentioned, one key part, I think, of our public advocate or special advocate proposal is reporting, so that people do have a sense of whether or not the special advocate is being appropriately utilized. We also recommended that the government work with providers and allow private parties who are compelled to cooperate with the government by court order to allow them to explain in some greater detail to what extent they are under these court orders and how much information they are providing. I think all of us share the view that more transparency, more reporting is better, but the devil here, too, is in the details. And so I think there's a recent settlement between some of the providers and the government that I think everyone acknowledges is a step in the direction that we certainly think they should be going. And I think over time we'll see. First, what is a meaningful report? Is it an order? but if an order covers 1 million accounts, that really doesn't tell you anything. Is it the number of accounts? Is it the number of U.S. persons? There are a variety of ways to do the reports, and what we recommended was an ongoing dialogue between the providers and the government outside the context of litigation, but just as a good public policy approach going forward. We also recommended that there are various reports and opinions that the FISC is required to provide to the House and Senate Intelligence Committees, and that we should also receive those opinions as a matter of course. It's not just on the judiciary. Obviously, it's not just on the FISC in terms of transparency. It's on the government. And so we recommended that the executive branch also start to develop in a meaningful way its principles about transparency. And I hope we will have the opportunity to work with them going forward. The final recommendation, which was not unanimous, but I again would say, look to I recommend, the 5-page dissent, not necessarily the whole 210-page full report, but, how can we explain better how the government is using the authorities that are provided to them? And, what struck me in the course of the discussion about Section 215, and there's an analysis of the interplay of Section 215 and ECPA, which Jim had mentioned, ECPA only applies to certain types of communications. So where on the scale would this fall? So is it that we would have a public discussion that Section 215, which, by the way, if you do read it, it's a lovely read, the statute itself. It clearly contemplates non-particularized collection. But how much? What does bulk mean? Could we have a public discussion about that? But if we were going to have a public discussion about a particular program, and we had to also then publicly say, well, ECPA is implicated, I think that's another step, and we're giving our adversaries a lot of information then about precisely the types of information that the government is attempting to obtain. But we were largely unanimous, and I think the spirit of our report is very clear that where the government can operate more transparently, can educate the public, it should do so. And it's part of our mandate, both by statute and also now by practice, such as it is over the last 15 months, to operate publicly where we can.
Wonderful. So we will hear from Professor Anne Joseph O'Connell.
Thank you for inviting me to comment on this remarkable report, including the two separate statements, dissenting in part. I stand here as someone obsessed with the administrative state, and so I want to make 3 points as an administrative law teacher and scholar. So I'm not speaking as a constitutional law person or a privacy law person. We have 2 commentators who will follow me, and I have to apologize. I have to flee to teach my 6:30 class, who will address some of those issues. So I'd like, in hopefully a short amount of time, to make 3 points from that perspective. Not all related, but all administrative law. So number 1, I think agency structure matters a lot, but so do staffing and resources. Number 2, I think this report should encourage us to think more broadly about having notice and comment of national security policies with implications for civil liberties by at least the board, and ideally by others as well. And third, I think that such notice and comment can both promote national security and civil liberties. The statute, the report, the framing of this event presumes a trade-off between the two, and I'd like us to question that assumption. So first, about agency structure mattering some, but so does staffing and resources. So this agency has a crazy history in a little over 9 years. So the Intelligence Reform and Terrorism Prevention Act that was signed by President George W. Bush in December 2004 created the first version of the board, essentially as an executive agency within the Executive Office of the President. Civil liberties advocates at the time called it a toothless panel. President Bush did not name its members right away, took a few months to name the members, and then waited 3 more months to send the nominations of the chair and vice chair, the only 2 positions that required Senate confirmation, to the Senate. The other 3 members, ordinary members, did not require Senate confirmation. The board didn't meet for the first time until March of 2006. It didn't last long, so it has its first meeting in March 2006, and then we get the implementing recommendations of the 9/11 Commission Act of 2007. The number of board members, as you know, is kept at 5, all of them appointed by the president, confirmed by the Senate, with 1 being full-time. As already mentioned, there are these 6-year terms before the members had served at the pleasure of the president. I think it's interesting that the statute mentions that the members are supposed to, quote, be selected solely on the basis of their professional qualifications, achievements, public stature, expertise in civil liberties and privacy, and relevant experience, without regard to political affiliation. As noted, it does stick on a party balancing requirement, as with many independent regulatory commissions and boards. It also adds a twist, something often done in practice, but not often codified in law. The statute says that the president shall, before appointing an individual who is not a member of the same political party as the president, so our 2 women on the end, the president is to consult with the leadership of that party, if any, in the Senate and House of Representatives. I think as a matter of structure, this was a good move in 2007 to make the board independent. But it's nice as a matter of theory, but the agency needs to be staffed. The statute was in 2007. We got our 4 part-time members in 2012. Our chair got confirmed in May on a straight party line vote. It's hard to start and maintain an agency. It takes personnel. That took a while coming. And it takes resources. I was so struck by a footnote in the separate statement of Elisabeth Cook. We have sort of, in addition to the 5 board members, there are 2 permanent staff members, but her footnote calls basically for more help for the agency. So the first point is give them more help so they can do what they do. And then the second and third points is about taking their report as a starting point for thinking about how we might be able to get prior notice and comment on national security policies with implications for civil liberties by at least the board and ideally by others. So this is drawing on some invited testimony to the Senate Judiciary Committee Subcommittee on the Constitution 2008 that Dan Farber and I, Dan is also at the law school, provided. And we propose there that absent a clear contrary need, that every national security policy with consequences for civil liberties and other democratic values should go through notice and comment procedures. So the ideal, where we note exceptions, would be that an agency desiring to implement a national security policy would provide prior notice of the policy and relevant information to evaluate rule of law concerns. The agency would then provide a period for interested persons to comment on the proposed policy, whether in support or in opposition. And then the agency would evaluate that information and decide whether or not to implement the policy as announced or in modified form. And if the agency decided to enact some version, it would have to defend, just as a normal rulemaking, defend its policies, offering responses to relevant comments and the like. So there might have to be some modifications to the idea that we would have public notice, prior comment before implementation, and also in the agency context, we allow some sort of review, typically in the courts. And so how might we think about this in the national security context? So think about the first attribute, it being public. Well, maybe not everything can be made public for interested persons to comment, but maybe at least some aspects could be made public. And even if that's not possible, maybe we can have commenting within a smaller group of entities within the government, so including the Privacy and Civil Liberties Oversight Board, but also civil liberties officers in the intelligence, defense, and homeland security agencies. We might allow commenting by, if we had to restrict how public it could be, by key committee members and staff within Congress, kind of larger than just the 2 intelligence committees, but kind of throwing in judiciary committees and the like. What could we do? So you might modify the public nature of the comment. We might have to modify the fact that we would seek the commenting, even in this small group, prior to the implementation of the program. Ideally, it would be done prior to an implementation of the program. But in the larger administrative state, we allow some possibilities for agencies to enact policies and seek commenting ex post. So outside the national security context, agencies very frequently use both direct final rulemaking and something called interim final rulemaking. And the idea is for direct final rulemaking, and it would be more than rulemaking, but also for policies that you implement something that you think is going to be non-controversial. So not this program and not the program under Section 702, but maybe on how certain contractors would get paid, for example, in the national security arena. And you announce the policy and you say, listen, this is going to take effect in 30 days unless we get adverse comments. So it would allow you to kind of take action, get comments later. Interim final rulemaking is for more controversial materials because you have good cause or some sort of emergency, so you need to act quickly. But what agencies do now is they have the interim final rulemaking and then they take ex post commenting. The last attribute about review is harder to think about. In the national security context, in the agency context, we go to the courts, and the report by the board focuses on kind of review in the FISC. But I'd like to think about review more broadly on these policies. And so maybe it's the director of national intelligence being required to assess every policy that has certain rule of law implications, and giving that opinion, to the agency, to the president, to the relevant congressional oversight committees. Maybe also having the Privacy and Civil Liberties Oversight Board being required to offer peer review with regard to the legality of particular policies with civil liberties implications, and that would kind of come close to the parallel. So I'll stop there, but it really, I read the 200 plus pages and the two separate statements, and there are a few appendices as well kind of thrown in. And you should read. Okay.
Thank you. So we'll now hear from Susan Landau.
So thank you very much. I'm from Google. I want to speak very briefly about transparency principles, mainly limiting government authority. There should be oversight and accountability of such interception, and we need to respect free flow of information. And now I'm starting to speak as me instead of as Google. So this is what I have to say from now on is not authorized by Google. First of all, I want to say how incredibly grateful I am to the board for the work on effectiveness. It's an issue that I've looked at for a long time, and I can't say how important it is, the work that you did on determining the lack of effectiveness in the metadata program. That's remarkably important. I want to tell you a story, and the story is a story of the last 30 years about cryptography, because I want to end by telling you what I think it is very important for your board to investigate. So I work in in security, public policy, and privacy. And one of the important aspects of that is cryptography, which, of course, protects the security of communications. Well, communications in transit and data at rest. And between the 1970s and the late 1990s, there was what was known as the crypto wars. It started first with the NSA attempting to prevent the publication of academic research, and then the NSA attempting to prevent, through the use of export control, the deployment of strong cryptography throughout the infrastructure. In 1987, we got the Computer Security Act, which put the National Institute of Standards and Technology, NIST, in charge of security and crypto standards for the non-national security agencies. But there was a little twist in the bill, and the bill said that there was a technical working group set up between NIST and NSA, 3 people from each, that was supposed to work on the standards. And for the next 8-10 years, the NSA component of that technical working group subverted NIST's capability of being in charge. And instead of coming out with standards that were good for industry to adopt, there were constantly standards that industry found very difficult. So while NIST's role was in developing standards only for, can you all hear me?
Yes.
Okay, good. While NIST's role was in developing standards only for the federal government, when NIST works effectively, its standards also get adopted by industry, both in the U.S. and abroad, and that's tremendously important. In the mid-late 1990s, there was a change in the technical working group, and the change happened not administratively, but simply by NSA appointing a different flavor of person from the agency. And it was people involved in what was called the Information Assurance Directorate of NSA into the technical working group, and those people believed in actually deploying security across the public infrastructure. And so what we had all of a sudden was a crypto standard, a cryptography standard, the advanced encryption standard, whose adoption by NIST was followed immediately by adoption internationally. What happened to enable it was a whole bunch of things. First of all, NIST made the proposed requirements, even its call for requirements, it made open to public discussion, and public discussion changed the proposed requirements. Then there were international open meetings to discuss potential standards. One of the meetings was in California, but another one of the meetings was in Rome to make clear that they really wanted international participation. There was a public evaluation, so while NSA did evaluation of the algorithms to see if they were secure, there was also public evaluation. And the public group, that is the group of academic and industry cryptographers, came to the same conclusion about which were the 5 strongest candidates. This candidate that was picked was a Belgian algorithm. And so, as I said, it got adopted immediately. What happened next was fascinating. The algorithm was adopted in November 2001. A year later, NSA approved the use of the algorithm for communications in top secret and secret communications, as long as it was an approved implementation, a secure implementation. What that meant is, if you're selling equipment to that meant defense contractors could then use AES, not just defense contractors, the Defense Department could use the advanced encryption standard in its communications, which created a bigger market. Once you create the bigger market happens domestically and internationally as well. So you had the National Security Agency pushing forward a strong algorithm for encryption that could be used by the public. Next thing that NSA did is they adapted a set of standards that had been developed by NIST for securing not a communication but an entire network. So how do you develop a network, whether it's a police network of communication or a private network? So it looked like everything was going great guns. And then we found out last fall about dual EC DRBG. Let me not call it that anymore. It's a random number generator. Now, why do we care about random number generators? Well, the way you build cryptographic systems is you have a strong algorithm for the cryptography, one that everybody agrees is strong, and then and so everybody knows how you encrypt. You don't keep the algorithm secret. What you keep secret is the key you use for encrypting. And so it's really important that the key not only be secret, but it be securely generated. If it's all zeros, if it's all ones, if it looks 0101, it's not a good key. It's easily guessable. So dual ECDRBG, this algorithm whom I shouldn't say this way, this random number generator, was a random number generator pressed by the NSA to be approved by NIST as a standard. Now, it was very weird that it should be that anybody would want it as a standard for generating random numbers, because it was slow, much, much slower than the usual algorithms for generating random numbers. But NSA said, we want it. So NIST began considering it. This was 2004. We found out just before Christmas, that is 2 months ago, we found out that NSA paid RSA, the company, $10 million. Now, it appears that they paid them $10 million in 2004 to adopt this algorithm as the default algorithm in its major cryptographic toolkit. What this means is that instead of using faster algorithms, better algorithms, to generate the random numbers, they were using this NSA-developed algorithm. Seems a little odd that they would use a very slow algorithm. This algorithm, by the way, is the algorithm that is used to generate the keys that when you have a secure web communication, HTTPS rather than HTTP, this is the algorithm that gets used. That happened in 2004, but we didn't know it in 2004. It appears that NSA also asked other companies to do the same thing, whether it also asked them in terms of asking them with some cash on the side, we don't know. 2006, NIST adopted the algorithm, made it a standard. It didn't make it a federal information processing standard, which would then require any federal agency to use it, but it did make it a standard. 2007, two Microsoft researchers pointed out there was a weakness, that if you knew the relationship between two parameters in the standard, you could decrypt. Okay, you had backdoor information. NIST did not withdraw the standard. RSA did not withdraw its use of the algorithm. Both of them did so in 2013 within days of information in the Snowden leaks in September, which indicated that the NSA had finessed the choice of an algorithm. So now what we've got is NIST, which had, having fought NSA and successfully became an honest broker in the late 1990s, the honest broker of development of cryptographic standards, all of a sudden becomes tainted in 2013. So what happened immediately? They had been developing what's another cryptographic algorithm, a secure hash algorithm. They had changed some parameters on it before they were about to adopt it. Because of all the uncertainty cast upon NIST, they went back to what had been originally accepted or proposed, because they were afraid that their modifications would be seen as weakening it, even though they strongly believed it did not. But it's much worse. What we've gotten is internationally there are calls to no longer use NIST. The Chinese, the Russians, Europeans are talking about developing their own standards. Now what that means is, and this all sounds terribly technical, and I apologize, I would like to take at least an hour or maybe a semester to explain it all, but I'll take my 10 minutes. What we had in the old world, that is before NSA messed with the NIST process, what we had in the old world was NIST was developing interoperable, strong security standards because they were done in an open process that everybody could see. What that meant is they were adopted internationally. And so you get strong security in the US, you get strong security internationally, and you also get a strong US industry. Okay, very important for national security. So what NSA did was a very short-sighted measure. What's happened now, the new world is, we don't have necessarily an interoperable. So far there's been no breaks, but the Chinese are moving in, the Russians are moving in, the Europeans are moving in. Now, the European standards will be interoperable, but we know from past practice in the mid-2000s that the Chinese standards are not. So what you get is a non-interoperable, weaker system with backdoors. You hurt U.S. industry, you hurt privacy and security of communications domestically and abroad, and you also hurt national security. I would urge the board to look at the issue, and then I have some recommendations about what might be done. Okay? How do you restore trust in NIST? Well, the first thing is NIST has already begun a review internally about what happened and where processes were broken. They also need to do a very strong external review with trusted people on the outside, that is, people trusted by the public to dig deeply. One of the interesting things that happened post the Snowden leaks was the statement by the White House that we are not now spying and we will not spy in the future on the communications of Angela Merkel and various other leaders of strong allies. It would probably be, it would be extremely useful to have a statement from the White House or NSA about not messing with cryptography and security standards. The importance of securing internet communications and internet protocols is really paramount. And I would urge you to think about that. And then finally, NIST is a small agency in terms of cryptography and security capabilities. It's never going to be able to compete with the NSA. But at the moment, it has 7.5 people doing cryptography, 5 people doing protocol analysis, tripling the number of people looking at the security of protocol analysis, because they not only look at their own standards, but they look at standards developed by the other standards organizations. Doubling the number of people working on the cryptographic security would go a long way to improving the quality of what NIST can do, and therefore the security and privacy of U.S. communications. Thank you.
So we'll have, that was great. Let's have Lee come up here, and we do have a hard stop. I've been told it's 6:30, so if we don't have to...
Incredibly quick.
Okay, then we'll take the questions that we can, and if not, you can. The board members will be available, and at our reception afterwards, you can ask questions. I will just add a word to what Susan has said so eloquently. Her book, Surveillance of Security, is really wonderful, and one of the arguments that she makes, and that I urge the board to think about, is she mentioned the need to, it's beneficial to the U.S. if the security industry in the U.S. is recognized, and it brings business then to that part of the industry. But moreover, it is ultimately short-sighted. The NSA, to the extent that it builds in the backdoors, it'll help, as Susan has pointed out in her writings, it's going to help not only NSA, but it's going to help all kinds of terrorists and other intelligence agencies that pose risks to our vital infrastructure. So that they will not ultimately only be NSA backdoors, but they'll be discovered by other entities, and Susan's written about that very eloquently. And so you really get into a sorcerer's apprentice type situation in which you get all kinds of other vulnerabilities, and it goes beyond the NSA situation. Lee.
Thanks. So I'm going to make 3 fairly quick points. 1, talk about bulk collection. 2, talk about transparency and accountability. And 3, talk about governance. And the last 2 are actually pretty closely tied together. So bulk collection. Obviously, that has been something that the board and everyone has been looking at. I want to emphasize, though, because I think that we don't get enough of it in the media or even in D.C. discussion, the issue of bulk collection is much bigger than the phone records program, right, which is under Section 215 of Patriot Act. And that's true for 2 reasons. First of all, even with respect to Section 215, there's been a lot of discussion of, well, it's metadata, how important is metadata? And yet there is absolutely nothing in the actual statutory language that is tied to metadata, right? It speaks of records. And the kinds of records it speaks of are all sorts of, library records, bank records, all sorts of records. There's actually nothing in the language of Section 215 that precludes the government, if it were to make the argument that, well, records would include stored communications, the actual, say, content of stored email. I don't see anything like that in the statute, and I think that one of the things that has distracted folks when they look at the 215 program and think metadata is that it's really not about metadata per se. The second point on book collection is, of course, the 702 program, which the board is going to take up next. And what I want to say about the 702 program is basically that while we hear a lot about the PRISM program, it is based on our knowledge that about 10% of the collection under 702 is the upstream program, which is one that appears to, we don't know a whole lot about it, but appears to simply vacuum up, harvest large quantities of communication off of the internet backbone, off of the phone company backbone. This is, from my perspective, a significant Fourth Amendment issue. And I think the question that we have to ask ourselves, because there are a lot of doctrinal ways that folks are looking at the Fourth Amendment question with 702. But to me, it is, whether the Fourth Amendment permits the government to foreseeably, knowingly collect large amounts of communications of persons in the United States, whether they're U.S. persons or non-U.S. persons, with absolutely no particularized suspicion as to those persons or to the communications, and where the court itself only reviews procedures. And I emphasize that last point. The court only reviews procedures. If you look at the text of the Fourth Amendment and you look at the text of its warrant clause, it requires that warrants be issued by a neutral and attached magistrate that speak with particularity to the things to be seized, which in a communications context are the actual communications, and the places to be searched, which, again, in the communications context could be an account, could be as large as a gateway where many, many communications are traversing. Those are what's supposed to be ruled on by a court in a warrant proceeding. By not having targeting, by not having those things in front of the court is only getting sort of the middle, sort of this is how I would do something if you were to let me do it, except for under the statute, the Attorney General and the DNI, the Director of National Intelligence, actually decide which are the targets. And what we surmise based on the Snowden documents is that there's something like 115,000 of these non-U.S. person targets, which may not necessarily be individual, but could be groups, could be companies, I'm not sure. And so neither who nor the place to be searched is actually in the hands of the FISA court in this process. I guess I would submit, just as a prima facie case, that seems really obviously inconsistent with the Fourth Amendment. On the point of transparency, we have, EFF has been litigating cases around the NSA program since 2006. And one of the things that became very, very obvious to us early on was that we were engaged not only in litigation about whether or not the government was acting properly in collecting in records and information without judicial approval, but also we were doing impact litigation on classified information, on the state secrets privilege. Because what we really have is an enormous amount of secrecy, an enormous amount of classified information, which makes it very, very hard for the public, for legislators, and for courts to actually, and for litigators like myself, to actually get any kind of traction when we believe that there are constitutional or legal violations. And 2 points that I think are, end up being obviously significant in the last several months is we don't know very much about the effectiveness of programs. This is something that, the board has definitely looked at, but it's very hard for the general public to get any kind of sense of effectiveness when the only source is from the community that established the programs in the first place and is now sort of grudgingly being forced to talk about it. Second, and obviously there's a great deal that should not be classified, or at least we need to have an open debate about, is what the law means, right? I mean, there is what we have seen in the declassified opinions. What we have seen is essentially that there's been a system of, you might as well call it secret law, operating because the words on the pages in the books don't mean what we think they mean. And they haven't meant that for a number of years. And when it's not possible, when that is not coming out, then we have a serious feedback problem in the system of governance, which is, my last point. How do you deal with this kind of structure where essentially the power to keep things secret, the power to keep them even secret from the courts, essentially means that the intelligence community, as the part of the executive branch that is doing this, has an enormous amount of sort of extra enhanced practical political power within the system of separation of powers. It makes it difficult for Congress to oversee them. It makes it difficult for courts to oversee them. We end up with a secret court, something that a lot of folks think is problematic for a constitutional system. And yet it feels like you have to have that in order to accommodate these supposed secrecy needs. Similarly, the Senate Select Committee on Intelligence or the House Permanent Select Committee on Intelligence. These are committees that are supposed to represent us as sort of the elite overseers of the intelligence community. And yet we have heard that even within those committees, it's very difficult for the members to understand what exactly is going on. This is not just a legal issue. This is also goes to technology. And indeed, my reading of the Fisk opinions, as well as many of the things that the members of these committees have said, it seems quite clear that they have not had the benefit of adversarial or even independent discussion, analysis of what exactly it is the government is doing. And that's the point I'm going to end on, which is, there's a lot of proposals for reform out there, and many of them, I think, are probably quite good. But you cannot actually have, in my view, any reasonable claim to reforming a system like this, especially now that we know that there is so much that we did not know, and that there are many things that we have been doing based on ignorance. It is time now for us to actually focus first on learning what it is that has been happening in the name of fighting terrorism or whatever. And once we actually have something like a modern church committee that, armed with the legislative power of Congress, can actually go in and try to ferret things out, once we get the big picture, because we do not know what we do not know, then maybe we have a shot at creating a governance structure that can actually mean that what the government is doing in this area is consistent with what the people want and with what the Constitution says. That's it.
Thanks so much, Lee. So I've been sort of. Do we have time for one question? Would that be okay? So why don't we'll have one question to the board, and then we will conclude. Would anyone like to ask a question, or should we? Okay, then. Oh yes, excellent.
My name is Xavier Molina. I'm a student at the School of Information, and I'm actually working with Deirdre Mulligan on some of these topics. And I just had a question specifically related to location information. So I know, as you mentioned, Rachel Brandon, that as far as metadata goes, it's what number called what number, et cetera. I noted also that in some of the documents that have come out that they specifically prohibit the collection of cell site location information. However, some of the orders that have been released or leaked do mention that trunk identifier information is collected, and I was just wondering, how much those two statements conflict, because there are multiple statements saying that location information isn't being collected. However, trunk identifiers often include what cell tower it entered into, and et cetera. And so I was wondering if you'd address those concerns.
Do you want me to address it, or do you?
Whoever knows about it.
I'll say something, and I'll defer to Jim, who's a real expert on these things. I mean, there is some. If you have a landline and it has an area code, that tells you something about the location the person is, right? So it's not like there's no location information included in metadata. The government does not collect cell tower information, but that's a cell phone specific, piece of data, whereas the landline is a different issue. In terms of trunk identifier, I believe that is collected, but Jim, do you?
Yeah, it is collected.
On that?
Rachel said it right, that cell tower information is not collected. We're pretty confident that it is not. Trunk identifier information is collected. You can draw from it what conclusion you want. I think it's pretty clear the government has been careful to say we are not collecting cell tower information under this program. They tested it for a brief period of time and left it alone after that. The theory of the orders might well allow it. It's not happening. I'm quite comfortable in accepting that it's not happening. We've looked at the sort of list of fields that are required, and I think the government has been clear. We are not collecting cell site information. We are collecting trunk identifier information, period.
Excellent. So why don't we continue outside of the reception, and thank you to the board.